Welcome to the Introduction to the ADA and Self-Advocacy video training. My name is Jessica Payson. I am a staff attorney at Disability Rights Maine. So first, just to get started, just to clarify that this training is going to be for educational uses only. It's not legal advice. And although this material is timely as of the date it is being presented now, the law does change over time, so the information contained in these materials may become outdated. Uh, so before you use any of the information provided here, please do check first to make sure that it is still accurate. The presentation today is going to start with an overview of Disability Rights Maine, who we are as an organization. And then we're going to talk about the primary federal law protecting the rights of individuals with disabilities, the Americans with Disabilities Act, that is the ADA. We'll talk about who the ADA protects and what rights the ADA provides. And then we'll talk about one way, one particularly important way to protect those rights through what's called reasonable accommodation requests. Then ordinarily in a training, we would have time for questions and discussion, but as this is being recorded, instead we'll just invite you to reach out to Disability Rights Maine should you have questions for us. Okay, who is Disability Rights Maine? Our mission is to advance justice and equality by enforcing rights and expanding opportunities for people with disabilities in Maine. We are part of a national network of what are called protection and advocacy organizations, or PNAs. This is a large national network consisting of 57 organizations across the United States, US territories, Washington, D.C. There's a dedicated tribal PNA in the Four Corners region. PNAs are a pivotal part of the disability rights movement, and we are governed by and, in fact, mandated by federal law. Disability Rights Maine, in particular, was founded in 1977 with one federal program, but now we operate dozens of federal and state programs. We operate statewide. We have two primary offices, but we have staff based all across Maine, as far north as Caribou. Our key priority areas as an organization, right, are as follows. The sort of bedrock priority for us is to eliminate abuse, neglect, and exploitation, especially in facilities. Additionally, our priority areas include reducing the use of guardianship, improving access to disability-related supports and services, including access to due process, increasing access to competitive and integrative employment, challenging housing discrimination, increasing access to inclusive education, and ensuring access to voting. Our services include information and referral, individual advocacy, legal representation, trainings, assistance with self-advocacy, outreach and monitoring. And if you would like to request assistance from Disability Rights Maine, all requests for assistance start with an intake, either a phone call or an email. This slide shows a link for our online intake form. Now, unfortunately, we cannot take every request that we receive, but we do strive to serve as many people as we can within our resources. The type of services we can offer depends on our priorities, which I discussed in a previous slide, as well as our capacity. But please know that Even if we cannot take your particular request, we do review every single intake. And even if we cannot provide direct assistance, the information that you share with us is important to us and can help inform our systemic work. To get into the specifics of this training, again, we're focusing on the Americans with Disabilities Act, or the ADA. We're looking at the rights that people with disabilities have under the ADA and how a person with a disability or an advocate can protect those rights. The Americans with Disabilities Act, as I said, is the primary law that guarantees the rights of individuals with disabilities who live in the United States. Its history is really interesting and important and empowering. And it came from the grassroots disability rights movement as part of the broader civil rights movement. It was part of a movement led by and for people with disabilities, as well as parents of children with disabilities. It was ultimately signed into law in 1990. The ADA, most basically, aims to prohibit discrimination against people with disabilities in most areas of daily life. And we'll go over that in a little more detail later. You can think of the goals of the ADA in a couple of different ways. One is preventing individuals with disabilities from being unfairly excluded or segregated from their communities. And the other, right, more positively, is to make sure that people with disabilities have the same opportunities as everyone else to participate in society. So this might become clearer with an example. Let's say that you live in public housing. So here's a photo of what the front door to your building might look like. Let's say your apartment is located on the first floor, but there is a set of one, two, three, four short steps to get from the sidewalk up to that main entryway. Now, let's say that you use a wheelchair. It would be enormously difficult, even impossible, for you to get in and out of the building. So as a result, you would be isolated in your house. You'd be excluded from, segregated from the rest of the community. And you wouldn't be able to participate in social opportunities the same way as people who do not use wheelchairs. So the ADA is meant to provide you with tools to fix this issue. In this case, for example, to demand installation of a ramp. The Americans with Disabilities Act protects persons with disabilities, but what is a disability? This training is going to focus on the legal definition of disability for obvious reasons, but I want to start by saying that there are many ways to define disability. And according to a recent census survey, about 1 in 4 adults in the United States identified as having some type of disability. So again, there are many ways to define disability. Medical institutions, define it somewhat differently than legal institutions. Even different areas of law might define it somewhat differently. And people certainly have different ways of defining it for themselves when it comes to defining their own identities. All of these definitions play important purposes and are completely valid, right? But for purposes of this training, we're going to be using the legal definition of disability as it's understood under the Americans with Disabilities Act. So we'll be referring to the definition, the legal definition, which may not be the one that you identify with or you even particularly like, but it is the one that is used legally under the ADA for the specific purposes of defining your rights and recognizing rights violations. Okay, so this legal definition under the ADA. what is a disability? Under the ADA, a person with a disability has to meet three different criteria. First, the individual has a physical or mental impairment. Second, that impairment limits a major life activity. Now, a major life activity could be one of two things. A major life activity could be the kind of activity that you do every day to take care of yourself, eating, sleeping, walking, hearing, seeing, learning. Or a major life activity could be defined as something related to basic bodily functions. For example, digestion, breathing, blood circulation. All right, the third component of the ADA's definition of disability is that the impairment has to be substantial. And by that, it's meant that the impairment has a severe impact on your major life activity, and it is expected to last a long time or result in death. This again may become clearer through example. So let's go back to that example we just discussed with public housing and the person using the wheelchair. Let's call him John. John is the tenant who uses a wheelchair and has that apartment on the first floor with the steps leading up to the entryway. John's backstory. John, as a very young infant, suffered head trauma that resulted in injury to the part of his brain that controls movement. He was diagnosed with cerebral palsy. So as a result, many of the muscles in the lower part of his body are constantly tight or stiff, which makes it extremely difficult or even impossible for him to walk. His condition will not get worse over time, but it's also not going to get better. Okay, based on what we know about John, does he have a disability under the ADA? Let's apply the three criteria. First, does John have a physical or mental impairment? Second, does the impairment affect a major life activity, understood as either a kind of daily care activity or a basic bodily function? And then third, is the impairment substantial? Is the impact severe? Is it expected to last a long time or result in death? So here, for educational purposes, if you want to pause for a moment and think through your answers to these questions, feel free. The next slide is going to share what I believe a court of law would most likely conclude about these questions. Okay, so I think most likely a court of law would say that yes, John does have a disability under the ADA. First, does he have an impairment? Yes. John has a physical impairment. You can say that it's physical in the sense that it originates in his brain and then affects his muscles. Does it impact a major life activity? Yes. Because of his constantly constricted muscles, John is limited in his ability to walk, lift, carry things, perhaps other daily self-care activities. In John's case, you could also say that it affects a basic bodily function, his ability to relax and constrict muscles. Finally, is the effect on the major life activity substantial? Yes. The impact's severe. It is insurmountably difficult for him to walk and do related physical functions. And it's expected to last a long time, permanently. No, note, by the way, in John's case, that second criteria about major life activity, in this case, he does, you can explain a major life activity in either of the two possible ways, the kind of daily, self-care activities or basic bodily function. But legally, you only need one or the other. Okay. Let's look at another example. Let's consider the case of Sarah. Sarah lived the first 20 years of her life in an area with high rates of violence. In particular, in her neighborhood, sometimes people would drive through the streets and shoot bullets out of the window randomly. Sarah witnessed violence towards her neighbors. She feared for her life. Sarah now lives in a neighborhood that she considers safe, but she keeps thinking back to the violence. As a result, Sarah hasn't had a full night's sleep in months because she's frequently woken up by nightmares. She's constantly aware whenever a car drives by her house, and she gets distracted by it every time. She's easily startled by loud noises. She's trying to take classes towards a college degree, but she's having trouble concentrating and has failed many of her assignments. Sarah talked to a mental health counselor who thinks that Sarah has PTSD and is recommending treatment for her. Even with treatment, though, her symptoms may last for years to come. Okay, same question. Does Sarah have a disability under the ADA? Well, do each of the three criteria apply? Does Sarah have a physical or mental impairment? Does the impairment affect a major life activity? Is the impairment substantial? And again, if you want to pause and think through these questions, feel free. The next slide is going to share what I believe the most likely response from a court of law would be. Okay, so I believe that this is another case where the court would say, yes, Sarah actually pretty clearly has a disability under the ADA. Does she have a physical or mental impairment? Yes, she has a mental health impairment. Does it affect a major life activity? Yes. Her mind keeps going back to a time and place where her life was in danger. So she's limited in her ability to sleep, to concentrate, to learn, and perhaps other things affecting her ability to do daily self-care tasks. And is this impact substantial? Yes, it's severe. She hasn't had a full night's sleep in months. She's so distracted that she can't pass her school assignments. And her symptoms are not expected to go away on their own. They're expected to require long-term treatment. So I include this example too because it's important to remember that not all disabilities are visible. And I think in both John's and now Sarah's case, I think it's equally clear that both have a disability under the Americans with Disabilities Act. Let's go over one more example. Let's say Robert is new to Maine. This is his first time living in such a cold weather climate. He's never had significant health problems before, but when he moved to Maine, he started experiencing increased sneezing, runny nose, itchy eyes, similar symptoms. The symptoms went away over the winter, but they were very bad initially when he arrived in the spring. Now, as it turns out, Robert's symptoms are caused by the pollen of a particular birch tree that is found mostly in areas of the world with cold climates. Robert's healthcare provider diagnosed him with a mild allergy to this pollen. Once the weather gets warm again, Robert is expected to need to take over-the-counter antihistamine tablets every day and use eye drops as needed. Okay. Does Robert have a disability under the ADA? Again, apply each of the three prongs of the definition. And again, pause here if you want to think it through for yourself. And then the next slide will give what I think a court is likely to say in response. Okay, first, does Robert have a physical or mental impairment? Well, yes, he has a physical impairment affecting his sinuses. Does it affect a major life activity? Maybe. Even though they've been diagnosed as mild, it's still possible that they disrupted sleep, for example, and sleep is a major life activity. But, right, is the impact substantial? No. The diagnosis specifically said that the allergy was mild, which suggests that it is uncomfortable for him to be outside sometimes, but not impossible. And even if he does have trouble sleeping sometimes, there's nothing in the fact pattern that suggested that it was so severe that he can't fix it with just, say, a simple over-the-counter antihistamine, and then get a decent night's sleep after. So, um, even though Robert meets one, maybe two of the criteria for disability under the ADA, he does not meet all three, and a court of law would quite likely say that this is not an example of a disability. Now, the point of this counterexample is I'm not trying to discourage anyone from advocating for their rights. I just want to make sure that folks are aware that sometimes there is legal dispute about whether someone has a physical disability. It could be because this, like in Robert's case, the dispute is about whether it has a substantial impact. It could be to do with dispute about how long something is likely to last. Right. So it is important in many cases to pay attention to these three prongs and think carefully about how they might apply. Okay, so we went over the definition of disability under the ADA. The next question, who does the ADA protect? Well, clearly, it does protect people who have a disability. It also protects people who are associated with having a disability. Right? So you can break this down into four categories. The ADA protects people who currently have a disability, people who have a record of a past disability, people who are regarded as having a disability, people who are closely related to someone who has a disability. Let's go over these in a bit more detail. People who currently have a disability. This would be, for example, John and Sarah in our previous examples. People who have a record of a past disability. This would be, for example, let's say Sarah gets treatment for PTSD and substantially recovers, right? Well, she would still have that record of a past disability. So if somebody discovers that record and discriminates against her on the basis of that record, right, then the ADA would be triggered and would provide her rights. People who are regarded as having a disability. This one you might think about Robert. Robert, we discussed, doesn't have a disability. He has a mild allergy. Say Robert wants to work in landscaping and he's qualified to do so, but his employer refuses to hire him because he believes that Robert's allergies are disabling, that the job would put Robert's life at risk. He therefore refuses to hire him, right? So Robert doesn't have a disability, but he's being discriminated against by his would-be boss because he's regarded as having a disability. So the ADA applies to him as well. Finally, the ADA protects people who are closely related to someone who has a disability. So for example, you might think of a parent of a child with a disability who applies for a job. The parent is the best qualified person for that job, but the employer refuses to hire them because they just assume that they'll take too much time off work to take care of their child. They don't hire them based on discriminatory biases and assumptions. And so this parent, again, would be protected by the ADA. All right, we've talked about who is protected by the ADA. What rights are provided by the ADA? The basic right is that a person with a disability or person falling under those other categories must be provided with equal opportunity to participate in every area of social life and not be discriminated against because of their disability. The ADA is broken into three titles, they're called, covering three broad areas of society. Title I covers employment, Title II covers government, and Title III covers public accommodations. So let's look at each one in a little more detail. Title I covers employment rights. So some of the most basic rights under the ADA for employment are that employers must provide you with equal opportunity to benefit from all employment-related opportunities. So this means jobs, right? Getting the job in the first place. It means promotions. It means the trainings that could open up possibility for promotion. It means pay. It means benefits. Anything that can be considered a benefit of employment, right, is something that a person with a disability should have equal opportunity to receive. Also, at work, you have a right to keep your medical information private. If employers want to know about it, they need a good reason. So this rule applies somewhat differently depending on what stage of employment you're at, if you're applying for the job versus if you have an offer for a job and so on. But the bottom line is that employers are limited in what they can rightfully ask you for in regard to your medical information. You also have a right not to be harassed because of your disability at a workplace. And you have a right to stand up for your rights. It is against the law for employers to try to force you to accept discriminatory treatment or to retaliate against you for having asserted your rights. Right. Let's look at Title II, government services. Governments must provide you with an equal opportunity to benefit from all government programs and services. And by all government programs and services, we mean, for example, schools, after-school programs that are run by public schools, transportation, healthcare, housing, insofar as it's public housing, for example, group homes, emergency services. If a program or service is offered by the government, then it must, right? The government must provide equal opportunity to benefit from it. Finally, Title III covers public accommodations. By public accommodations, we mean businesses that are not operated by the government but are open to the public. So grocery stores, daycare centers, doctor's offices, private, right, medical offices. The same basic rule applies here. Businesses must provide you with an equal opportunity to access their goods and services. Okay, so the kind of common denominator here is the right to access a program or service. What's it mean to be able to access a service? Sometimes to participate equally in an opportunity, the person offering that opportunity has to change something about the way they run their business, the way they run their service, in order to make sure that your disability doesn't stand in the way of your accessing it. In legal terms, this means that businesses, program services must make reasonable accommodations or reasonable modifications so that people with disabilities can access them. This brings us to one of the most important ways of protecting your rights under the ADA. The ADA gives you the right to ask programs, businesses, services, and so on to make changes that are necessary for you to participate. This is called a request for an accommodation or a request for a modification. If your request is reasonable, the business or program is required by law to grant it. So how do you go about requesting an accommodation? So first, address the request to the person who has the authority to grant it. For example, if it's to do with your housing, take it to the housing manager. If it's to do with your job, take it to your employer. Right? If it's to do with a government service, talk to the administrative officer, that's relevant to the issue. Identify who you are in relation to them so that they know how to identify you. Tell them you are their tenant, their employee, their client. And then tell them that you have a disability as defined by the ADA, and tell them the relevant way that disability affects you in relation to your ability to access their program or service. Identify the rule or practice that is hindering your ability to access the service, and then describe a specific change you would like them to make to that rule or practice and explain how it will help. Provide them with your contact information and a timeline for a response. So those were the bare basics. That's what's required. But here are some additional suggestions. Put the request in writing and deliver it in a way that you can confirm receipt. Legally, verbal requests, oral requests are just as legitimate. It's just practically they're harder to sort of produce a record of should you need to, file some kind of complaint. So it's recommended to put the request in writing. If your disability or disability-related need isn't obvious, it's recommended that you include a letter from your medical provider verifying that you do indeed have the disability and related need. If you don't do this, the person you're making the request from might come back at you and ask for this letter. So, and they have a right to do so. So you might as well just, if it's not an obvious disability, you might as well just provide the letter up front. But you do not need to provide more medical information than is necessary. And all that's necessary is that you say that you have a disability as defined by the ADA. You do not need to tell them what it is. Okay. Also, yes, you are advocating for your rights. And if your request is reasonable, you are entitled to have it granted, but still be gracious and kind, right? And thank the person you were talking with or making the request to for their attention to the matter. Let's go through an example. Let's go back to the example of John, who uses a wheelchair and whose only way in and out of his building is through the stairs. How should John make an accommodation request? Okay, well, first, who should John address the request to? How should he identify himself? What should he say about his disability and needs? Here's my recommendation. I would say John should address the request to the building manager or someone in a similar position of authority. He should identify himself. He should say, for example, I am a tenant in insert name of residence, living in apartment XYZ. And he should say, I have a disability as defined by the ADA, and as a result of my disability, I require use of a wheelchair. Again, he doesn't have to say he has cerebral palsy, right? He doesn't have to say, any of the medical details about what that means. He just needs to say he has a disability as defined by the ADA, and as a result, requires use of a wheelchair. Okay, what else should he say? He should specify the particular barrier that's causing him problems. And then he should propose a specific change and explain how it will help, and sign off with his contact information and timeline. So, for example, he might say, the barrier is the steps. The only way to access the building is through the front door, which has steps leading up to it. Because I use a wheelchair, I can't use the steps and therefore can't access the building. Then describe a specific change. You might say, I am requesting that you install a ramp so that I can use my wheelchair to get in and out of the building. And then you should provide contact information, timeline for response. Please respond to my request within 1 week of receiving this letter at his phone number or email. So on. Okay, so someone's written a request for an accommodation. When does the request have to be granted? The request has to be granted if three things. The alteration you're asking for is necessary for you to participate in the Opportunity Service Program. 2, it's not too burdensome to make that requested alteration. And 3, making the change won't alter anything fundamental about the service at issue. Let's go over these 3 things again in relation to John's request. Okay, is John's request necessary for him to participate in the housing service? Is it not overly burdensome? Is it not changing anything fundamental about the housing program? The next slide will provide what I think a court of law is likely to answer here. Yes, the request is necessary. And there is a typo there, I apologize. The request is necessary. Why? There's no other way for him to get in and out of the building. It would be one thing if there was a second door that would allow him just as easy access to his apartment, but in this example, there's not. So the request is necessary for him to make use of the building. It's also probably not too burdensome. The steps didn't look very tall. And if you looked at the space around the front door, it looked like there was plenty of space for a ramp. So it doesn't look like it would present any kind of administrative or financial burden, not much of one at least. And finally, his request for a ramp wouldn't change anything fundamental about the housing. I mean, housing providers have to provide ways in and out of their buildings. It's what they do. Ramps are a way of providing ways in and out of the building. So, right, it doesn't alter anything fundamental because his request is necessary, not too burdensome, and wouldn't alter anything fundamental. Most likely, a court of law would conclude that yes, it does have to be granted. Okay, so you've made your request. What happens after you make the request? Possibility 1. The person responds and says, yes, great. End of story. Possibility 2. The person does not respond at all. In this case, I recommend following up. This is the importance of the timeline. If you said, please respond within a week, that gives you full permission to, within a week, say, hey, I haven't heard from you. Ask if they got your request and when they think they'll have an answer for you. If the person keeps ignoring you or keeps putting you off, that might be tantamount to a denial. Okay. So again, too long a delay might amount to denial. How long is too long? Depends on the facts. But there is an expectation that they get back to you within a reasonable amount of time. Okay, possibility 3, the person does get back to you and they say no. Even if they say no, they are required by law to keep engaging with you. This is called the interactive process. They have to tell you why they're denying the request. And the reason has to be one of those 3 reasons we went over before. They think it's unnecessary, they think it's unduly burdensome, or they think it presents a fundamental alteration. And then they have to keep working with you to try to find another solution that meets your needs and does not have that identified problem. Okay, so we've gone over one of the major ways of advocating for your rights under the ADA, the reasonable accommodation requests. But please know too that there are other places you can look for help. Disability Rights Maine, right? And a number of resources we've listed here. We have a sample reasonable accommodation request form. There are links to, right, the State of Maine Department of Labor, New England ADA Center, ADA National Network, Job Accommodation Network. And um, please feel free to reach out to us with questions, with any concerns. If you believe that your rights have been violated, again, feel free to reach out, do an intake form. Uh, Again, we can't take every single request, but we do review all intakes that come in, and we do provide information and referral. Um, Even if we can't directly take on a request ourselves. Um, if this training has been helpful, feel free to click on this link to take a survey. Even if this training was not helpful, you should still click on the link and complete the survey. Tell us what you would have liked to hear more on, what could be improved on. And your responses will be helpful in creating trainings in the future. So thank you. And reach out to Disability Rights Maine with any of your questions or concerns. Thanks.